Hello and welcome back to class. Quick reminder before we get started, you do have a quiz due tonight, so if you haven't taken the quiz, please shut down this video, go take the quiz on Blackboard. Once you've submitted the quiz, go ahead and come on back to this video. I want to make sure you get that quiz done on time and you don't forget to submit it. So tonight is our last lecture where we will be covering new material. So this is the end of new material for the semester. Tonight we're going to go over what's going to happen next week, and we're going to cover a little more information about the final exam. Got some important reminders for you. I have a brief announcement about the New York State Police. I want to talk to you about criminal justice classes that are offered in the fall, that you may find interesting. More final exam reminders, and then we're going to cover our last bit of new material in Chapter 12 and Chapter 13. Here's our upcoming schedule. So starting April 30th, all course information will be available on Blackboard. If you remember, when you were studying for the midterm, all the information was available to you that we had done so far. All the videos, all the slides, everything was right there for you on Blackboard. After you took the midterm, I hid all that information because you didn't need it, and it just makes it a little easier to find things on Blackboard when there's less items there. But on April 30th, I'm going to reopen all that information. So every slide we've done all semester, every video, every handout, anything we've covered the whole semester will be available, and I'll put it back into chronological order so you can follow the material from the first night of class all the way through tonight's lecture and the final exam review. So that will happen on April 30th. Before next week's lecture, you're going to receive a list of topics and study suggestions for the final exam, and I'll send that to you through your email. Copy will also be available on Blackboard. Please have that handout ready and with you when you're watching the May 6th lecture so you can kind of follow along and see what topics will be covered on the final exam. We discussed earlier, and it still holds true, that I already tested you on weeks 1 through 7 material when we took the midterm. However, this is a cumulative final exam, which means I can cover material going all the way back to the very first night of class. However, since I tested you on a lot of that material on the midterm, the large majority of the questions on the final exam will be about material we covered since the midterm. However, there are some very important topics that are critical to the study of criminal justice in the first half of the semester, and they will appear on your final exam. So don't stress about any of this right now. Next week, we're going to cover everything. So on May 6th, I'm going to go back to the beginning of the semester. I'm going to lecture on topics we've covered from the very first night of class all the way through to tonight's lecture. And I'm going to answer a whole bunch of questions that have been submitted, but that I haven't posted or given you the answers for. So all that will happen on May 6th. So once you get the handout in your email with all the topics and study suggestions, and once we go through the lecture on May 6th, I think you're really going to feel pretty confident about the final exam, and you'll definitely know what to expect. Here's your warning for tonight. At 5 p.m. on Wednesday, May 13th. That's the day of the final exam. On the day of the final exam at 5 p.m., all of the information from the class is going to disappear on Blackboard. At 5 p.m., you're not going to be able to see any slides, any lectures, any handouts, any videos, nothing. It's all going to disappear from view starting at 5 p.m. on the day of our final exam. So I'm just telling you that now. So as you're studying for the final exam, you're going to know that's going to happen and you can plan your study time accordingly. Few quick reminders about the final exam. The date is Wednesday, May 13th. That's the same date that is on the syllabus, same date all semester. That's never changed. The only difference is you're going to be taking the exam on Blackboard instead of taking it in our classroom. You must start the exam at 6 p.m. You must submit the exam by 9 p.m. You have the full 3 hours to complete it. few reminders about that. We've had some flexibility in you taking your quizzes between 6 and 8 p.m. That is not true for the final exam. You must start the exam at 6 p.m. and you must complete it by 9 p.m. Just like with our quizzes, that once you start it, you have to finish it, that also holds true for the final exam. So when you start, make sure that you have the next 3 hours free, because once you start the final exam, you must complete it. You cannot save some answers, go do something else, and come back to it at a later time. I and Blackboard won't allow you to do that. During the exam, you are expected to use only the material in your own mind and brain. Your textbook, your phone, Google, notes, any other textbook, any other material, any notes that you yourself took in class, all of that is prohibited. You are under the honor code at the college to take the exam only with the knowledge in your own brain. Now, if you want to have some blank scrap paper with you and jot down a few notes or things to remember or to remind yourself to go back to a question, that's certainly acceptable, just like it would be in our final exam. But just as if we were taking it live, the expectation is you are not referring to any other materials. The format will be 75 to 100 questions. I have not finished your final yet, so I don't know the total. I'm not trying to be cagey. It's not done yet, but it will be between 75 and 100 questions. It will look an awful lot like the quizzes you've already taken. There'll be multiple choice. You'll need to write in the answer. There'll be true false questions, matching, etc., a whole bunch of different types of questions, all of which you've seen before. And it's very important that you remember the final exam is 25% of your course grade. As I explained the night we covered the syllabus, that's not my rule, that's the department's rules. And anyone else who's taking intro to criminal law will also have a final exam that is 25% of their final grade. So that's huge. If you're not doing as well as you would like to be, the final exam is weighed so heavily, it can really raise your grade if you do well. If you're already doing well and you figure, I got this, I don't need to study, I know everything, and you do poorly on the final exam, it can take your A grade and bring it to a B or lower. So whether you're got the exact score, you're right where you want to be in class, or you're not doing as well as you would like to be, it's critical that you really study for the final exam and that you're prepared for it, because 25% is a very large percentage. The New York State Police were supposed to be on campus last week and do a live info session for students, just like they do sessions for transferring to other colleges. They were supposed to be set up in the campus center and available to pick up written materials, ask questions, meet one of the troopers, and of course they couldn't come to campus due to the COVID-19 situation. I think what they did do was they did some sort of session on Zoom that people could join. That was the plan. I don't know if that actually happened, but in any case, I wanted to tell you some of the things that they wanted to convey to criminal justice and other students. One is that the salary you get when you start becoming a New York State trooper is pretty darn good, $57,000 a year when you're in the academy, and that increases to $81,000 after 1 year. That is a really high salary when you compare it to other law enforcement agencies, so that's definitely something to consider. There's different requirements for which phase you are in of applying for the job. So if you want to submit an application and you want to take the state trooper exam, you must be a U.S. citizen, you have to be a high school graduate or have your GED, you must be at least 20 years old, and you can't be older than 29. I'd put the asterisk next to 29 because there are some exceptions to the age rule if you have military service. So if you are a veteran, that age requirement may not apply to you. But if you're not a veteran, you must have reached your 20th birthday and you must not have reached your 30th birthday. That's just to fill out the application and apply to take the state trooper exam. Once you've taken the exam and you've met all the other requirements and gone through all the physical fitness testing and everything else, and you're accepted into the training academy, by that day, the day you walk into the training academy, you must have completed 60 credit hours of college coursework and you must be a New York State resident. So if you look at that and you say, oh, I got nowhere near 60 credit hours, well, that's okay. That doesn't matter because just to apply, you don't need 60 credit hours yet. You need 60 credit hours when you enter the academy. And if you applied to be a New York State trooper today and you're accepted, it could be a year and a half, possibly due to the COVID-19 situation and due to delays that's caused. It may be 2 years before you actually walk into the academy. So there's all sorts of information about the state trooper exam, all the qualifications for fitness and background checks and drug testing. All that information is on their website and the address is there for you. If you are interested in taking the state trooper exam, I strongly recommend that you sign up for it now. It's a $20 fee. I'm sure there's information on their website about waiving that fee if that's something you cannot pay right now. But I would definitely get on this if you're interested in taking it. Remember that the COVID-19 situation has caused a number of delays. You don't want to wait and say, well, I'll take the exam in 2021. It may not be offered in 2021. So if you're interested in the New York State Police as a career, I strongly recommend that you apply now, and they are accepting applications until September 13th. Trooper McLaughlin was on the live session. If it in fact did occur, he was, of course, going to come to campus, and his email is here. So if you have very specific questions and you can't find the answer on their website, go ahead and email him directly and get your questions answered. We're going to talk for a second about other criminal justice classes that are offered at the college. Remember, this is Intro to Criminal Law. So we covered a wide variety of topics very quickly. We didn't spend a lot of time on any of the topics, even the ones that are most critical to the study of criminal justice. That's because this is an intro course. So we're just introducing you to a number of concepts that are really important in this field. Of course, there's other courses at the college that really go into some of those topics in depth. For example, we spoke earlier about how the justice system is different if you are under 18. Well, we have a whole class that's juvenile delinquency, and you can spend the whole semester really looking in depth into those issues related to how the juvenile justice system is so much different than the adult justice system, especially in New York State with all the raise the age requirements that just changed in June of 2019. So that's a very interesting class. Homeland Security and Terrorism, we didn't talk about that at all. We skipped that chapter due to time constraints. You can take a whole course in that. If you find the information we're doing on the Constitution interesting, like the 4th, the 5th, the 6th Amendment, what police officers are allowed to do, how they're allowed to do it, when they're allowed to do it, taking policing, constitutional law, substantive criminal law, and criminal procedural law. Those are great classes where we really get to look at that information in depth. I've told you in the past, I teach criminal procedural law. We spend the first 4 to 5 weeks just on the 4th Amendment. That's all we talk about because it's such a rich field and there's so many questions that need to be answered. We spend a lot of time on that. So I looked up the college schedule. All of these courses right now are going to be offered this fall. 1 or 2 of them is only offered online. All the rest of them have live sections. Okay, so if you're interested in taking any criminal justice classes this fall, I would definitely register for them now if you haven't already. Your academic advisor is still available to you. All you have to do is email him or her. A couple of you have asked what other courses I teach here at the college. I teach Intro to Criminal Justice. I am on the schedule to teach that this fall on Tuesday nights. Of course, I am an adjunct, I am not a full-time faculty member, so I can be on the schedule and be taken off the schedule. And I don't get a whole lot of notice about that, but right now I am on the schedule to teach Intro to Criminal Justice. I also may be added for another course. I also teach substantive criminal law. That's sort of part 2 of this class. So if you found this class interesting and want to learn more about criminal law, that's substantive criminal law is part 2 of this course. I may be teaching that next spring. Criminal procedural law is one of my favorite classes I've ever taught. I really enjoy teaching that class. And if I'm teaching it, it's almost always in the spring semester. And if you see me on the schedule, I'm teaching at night. I don't teach any day classes at all. So I strongly recommend that you consider taking more criminal justice classes. I mean, obviously, if you're a criminal justice major, you don't have any choice, but we have a lot of individual studies and students with other majors in the course. So I'm really talking to them and encouraging them to further examine what we have to offer in this field. All right, now let's get to the material tonight, and there's a lot of it. So take a deep breath and grab your coffee because we're going to be here for a bit. So we've looked at this slide last week, and this slide, as you remember, is the Star Chamber in Great Britain, where people were routinely tortured into confessing to crimes, held in trials that were performed in secret, not given a chance to defend themselves. It was just, it couldn't have been a worse situation if you were accused of a crime. You could just almost always be assured you were going to prison. You wouldn't have any help from an attorney. You weren't allowed to question witnesses. You weren't allowed to testify on your own behalf, right? So if we look at the top of this list, the first item we talked about was that your home could be searched at any time. The police or the government or anyone who worked for the king or queen didn't have to tell you why they were there. They didn't have to tell you what they were looking for. And of course, we got that corrected in the Fourth Amendment. We talked about that previously. Another thing that could happen back then was you could be tried for the same crime over and over again. And we corrected that in the Fifth Amendment. We talked about that last week. So all these other issues, things like being tortured or forced into confessing, that the laws were applied to everyone differently, that you could be held in jail for months or years waiting for a trial. All of these items in this whole list are covered in the Fifth and Sixth Amendment. The only one we've done so far from the Fifth was double jeopardy. So tonight we're going to work our way all the way through the Fifth and the Sixth Amendment. So let's start with the Fifth Amendment. This is the Fifth Amendment in its original language. This is how it appears in your textbook. There's a lot to it, and we can skip the first 2.5 lines because well, let's talk about it. Let's go ahead and get into it. So no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. We'll talk about that briefly in a minute. When in actual service in time of war or public danger. So remember that we talked about quartering of soldiers and how people were treated during war. So that's what this relates to. Doesn't have a big implication for us now, but grand juries do, and we'll talk about that in a second. Nor shall any person be subject for the same offense to be put twice in jeopardy of life or limb. That's double jeopardy. We talked about that last week. Let's move on to nor shall be, it should be, nor shall he or she, that's not what it says, nor shall be compelled in any criminal case to be a witness against himself. That's self-incrimination. We're going to spend a lot of time on that tonight. Nor be deprived of life, liberty, or property without due process of law. Nor shall private property be taken for public use without just compensation. Now let's break that down a little bit. So the first part about it talked about your right to a grand jury. New York State does use grand juries. Almost all the states do. The only exception is Pennsylvania and Connecticut, and they have a different way of conducting the same thing, but it's not called a grand jury. So New York State does use grand juries. It is very important that you know that and know more about what a grand jury is. Double jeopardy, we're not going to get into that tonight because we talked about that last week. We're going to spend a lot of time on protected from self-incrimination. Due process of law is also in the Fifth Amendment. And for some reason, and I don't know why, eminent domain, which we talked about a few weeks ago, Remember, for example, if the county wants to put a fire hydrant into your neighborhood and wants to put it in your lawn that you own, they are allowed to do that. However, the Constitution says it requires compensation. So they do have to pay you money to do that. It's usually not a lot of money. They're also required to fix your lawn after they do it. So they kind of have to make things right for you. But the government, under certain situations involving things like public utilities, public safety, sewer lines, water systems, that sort of stuff, they are allowed to put that on your private property. However, the Fifth Amendment says that they do have to pay you in order to do that. Not really sure why that's there. Let's go to the Sixth Amendment. It's really hard to talk about the Fifth Amendment, protection against self-incrimination, and the Sixth Amendment, right to counsel, separately. They really go together, and you'll see why in just a minute. So this is the original language of the Sixth Amendment. This is what you'll see in the back of your textbook. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law. That's all about the location of the trial. We'll talk about that in just a sec. And to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and what we're really going to focus on tonight, and to have the assistance of counsel for his defense. Let's break that down a little bit. Awful lot of really important stuff in the Sixth Amendment. That's where you have your right to a speedy and public trial, an impartial jury. That's for criminal cases. Trial is where the crime is committed. Remember back in the old days, we talked about how you would be charged for a crime where you lived, and you could be held in jail and tried hundreds of miles away from where you lived. That's a really difficult position to be put in because you don't have any way to talk to friends or family. You don't have an opportunity to talk to anybody who can help defend you, right? So that's a really problematic thing. So they said in the Sixth Amendment, you have a right to have your trial where the crime was committed. Of course, that doesn't mean on the spot of the crime. We don't hold trials from crime scenes, right? It means in the town, village, city, county, right, where the crime was committed. The Sixth Amendment also gives you the right to confront witnesses against you. We'll talk about that further in just a minute. You also have the right to call witnesses to testify on your behalf, and you have the right to an attorney. The Constitution says counsel, that's interpreted to mean attorney. So you do have a right to have an attorney. You don't have a right to an attorney all the time, every time a police officer is talking to you, right? If you get pulled over for speeding and you say, I want my attorney, that's not going to help. You don't have a right to an attorney when you get pulled over for speeding. We'll talk about that more tonight. So, this case, of course, is huge, and most of you already know what this case is about because you've heard about it in every legal show or movie, anything you've ever seen about criminal justice. You hear it on Live PD 2 or 3 times an episode, right? This is Miranda v. Arizona. You need to know the correct name of this case, which is why I underlined it and put stars all over it. You must know the name of the case is Miranda v. Arizona. That's very important. You also need to know the year it was decided, which is 1966. So the case of Miranda v. Arizona in 1966, decided by the U.S. Supreme Court, and the specifics are on page 371 of your textbook. Miranda versus Arizona was actually 4 cases that went to the Supreme Court together. They presented similar issues, so they put the cases together, they tried them, the appeal was processed at the same time. So the Supreme Court was looking at 4 cases, one of which was Miranda versus Arizona. So the other 3 got lumped into Miranda versus Arizona because they presented similar issues. What happened with Miranda was Ernesto Miranda was suspected of raping and kidnapping an 18-year-old girl, and he was subsequently arrested for that crime. Once he was arrested, he was brought to the police station and he was interrogated for over 2 hours. He gave a verbal confession, And then, so he spoke and said, this is what I did. This is what happened. The officer who was there then wrote down what he said on a form. The form that the confession was written on had a heading at the top. And the heading said, I do hereby swear that I make this statement voluntarily and of my own free will, with no threats, coercion, or promise of immunity, and with full knowledge of my legal rights, understanding any statement I make may be used against me. So that's written at the top of the form. Then the officer writes down his confession, and then he's expected to sign the confession, right? So up until the time of Miranda, when you were arrested and put into custody, taken to the police station, handcuffed and put in the back of the police car, whatever that arrested looked like, and the police started to interrogate you, they did not have to tell you your rights. They did not have to say, okay, look, you're being arrested for committing a serious crime here. And if you say anything, if you admit that you were even there or you know someone who was there, if you say anything about this crime, we're going to use it against in court. They didn't have to say that. They didn't have to explain it. They didn't have to tell you, you have a right not to talk to me. Once you've been arrested and you're in custody and you're being interrogated, you have a right not to say anything. They didn't have to tell you that. It was expected that, one, you knew your constitutional rights under the Fifth and Sixth Amendment, and secondly, it was presumed you understood them. Now, it's one thing to say you have a right to remain silent. Anybody can say that. But what does that really mean? We spend months talking about it in our criminal justice classes. What does it mean to have a right to an attorney? People were just expected to know what that meant, to even know that these rights existed. And Ernesto Miranda, who was Latino, didn't even speak English very well. And now he's expected to know and understand these rights. And when I just read that passage to you, I do hereby swear, and no threats, coercion, or promise of immunity. Immunity? What are we talking about immunity here, right? I would bet that Ernesto Miranda did not fully understand what this heading meant. And once he signed that confession, what the consequences could be. And similar situations happened in the other three cases that were combined with Miranda. So what the U.S. Supreme Court was asked to decide is it constitutional? Is it legal or fair for the police to arrest you and interrogate you without telling you your rights? That's pretty much what the case boils down to. Now, the actual decision and the briefs and everything covered thousands of pages, but that's the essential issue of Miranda v. Arizona. Do the police have to tell you you have certain constitutional rights once they've arrested you, but before they start questioning you? And that's the key word here, is before. And back in 1965, they did not have to tell you any of these rights. So this is the case that was presented to the U.S. Supreme Court that they needed to decide. And this is what the court decided. The U.S. Supreme Court ruled when a suspect is in custody, they must be informed of their rights before they are interrogated. Now, that's really, really important for you to remember, so I'm going to say it again. The U.S. Supreme Court ruled when a suspect is in custody, they must be informed of their rights before interrogation. The court did not dictate what an officer had to say to someone, but they did rule there's three things you have to say. One is you have the right to remain silent. The second is any statement may be used against you. And the last part is that they have a right to have an attorney. And if they can't afford to hire an attorney, that one will be appointed for them. So the Supreme Court did not issue a statement in the Miranda decision that said, this is what you're going to say to people and this is how you're going to say it. But they did say, you will make sure you say these three things. And what this is developed into over time is what we all call the Miranda warning. And it's written on cards that police officers carry to ensure that they say it to people the same way every time. And if you watch Live PD, you'll see a police officer take out his Miranda card, and you know he memorized this thing like 6 years ago, right? But police take out the card and they read it to you exactly as it's written. That's to make sure that they don't miss anything. And when they're in court 6 months, a year, or 4 years later, they can say, I read him his Miranda warning. I read it the same way every time, and I use this card, right? It just helps them in testimony later on. This one at the bottom has what they call a waiver, where it says, do you understand each of these rights I have explained to you? Having these rights in mind, do you wish to talk to us now? Now, the Supreme Court didn't require that. This is just good practice that is developed into common police procedure. So the Miranda warning, as is done today, as you've heard a million times, starts with you have the right to remain silent, that anything you say can and will be used against you in a court of law, that you have the right to talk to a lawyer and have him present with you while you're being questioned, that if you cannot afford to hire a lawyer, one will be appointed to represent you before questioning. And if you decide at any time to exercise these rights and decide not to talk, that you have the right to do that. So even if you say, yes, I understand my rights, but I want to tell you what happened, I didn't do anything wrong, or I want to explain the situation, that you can start talking to the police and then change your mind and say, no, I want to remain silent. So that's these rights that are read to you. Now, we could have lots of discussion, and I bet if we were all sitting in our classroom, we would have lots of discussions about, does somebody really understand their rights and the consequences for waiving them when in the midst of being arrested, an officer pulls out a card and reads something to you? Are you really taking this in? And the answer is, it depends, right? What did I tell you? A lawyer's favorite answer always is, it depends. But it's a heck of a lot better than what we had before Miranda versus Arizona, which is nothing. And note in the facts of the Miranda case, when Ernesto Miranda was in the police station, he confessed verbally, and then the police officer wrote this on this form. So looking at that form is the first time he's being told about these rights, at least a couple of them, and he's already confessed, right? That's why the crucial word about the Miranda warning is before interrogation. The police are required to tell people that have been arrested what their rights are before they interrogate them. And even if the person says, I want to talk to you, I want to tell you what happened, I want to explain the situation, even if they start talking, they can change their mind and say, I don't want to talk anymore. That's their constitutional right. So when is the Miranda warning required? It is absolutely critical that you memorize this and tuck it in your memory bank. The Miranda warning is triggered. That's the word we use in legal parlance. The Miranda warning is triggered. It becomes required when the person is in custody before interrogation begins. In custody before interrogation is. Notice it doesn't say arrested. We're going to talk about that in just a second. The Miranda warning is triggered. It must be given when a person is in police custody before interrogation. Well, what does in custody mean? Well, it means one of two things. Certainly, it means you're arrested. If a police officer says to you, you are under arrest, you are now in custody, right? That's a real cut and dried one. If a police officer says, you are under arrest, I am arresting you, you've been arrested, well, you're in custody, right? You can't just go, yeah, I don't feel like being arrested. I think I'm going to go home and watch some Netflix. Once you've been arrested, you're going into police custody, right? So arrested is easy. If you've been arrested, you're in custody. The second part is a little trickier. So in custody, for purposes of Miranda, could also mean You're just not free to leave police presence. You don't feel free to leave. So maybe a police officer has not said, you are under arrest. You have been arrested. Maybe they haven't said that. Maybe you just don't feel like you really know what's going on, but you definitely know you're not allowed to walk away. So to determine if a person is not free to leave, the test is totality of the circumstances. So determine if somebody is in custody. There's two relevant factors. One is, have they been arrested? If they've been arrested, they are in custody, end of analysis. But it isn't just about being arrested. If you do not feel free to leave the presence of a police officer or officers, you're also in custody. To determine if a person is not free to leave, what you look at is the totality of the circumstances. This is a term we use in criminal justice a lot, and it means exactly what it says. Look at all of the circumstances surrounding the situation. So let's try that analysis. This case, Orozco v. Texas, is 1969. You don't need to remember this case name or the year it was decided. I just want to point out it's just a couple of years after the Miranda decision. And the case is referenced in your textbook on 367. They don't give you the name of it because you don't need to memorize this right now, but this is discussed in your textbook. Here's what happened here. So this is back in the late 60s, and a woman is running a boarding house. Now, we don't see boarding houses a lot these days, but imagine a huge house divided into multiple apartments. So this woman owns the home, and she rents rooms to people who need a place to live. So she's running her boarding house, and at 4 a.m., the police come knocking on her door. She says, what do you want? They say, we need to see one of your tenants. We need to see one of the people renting a room from you. She says, sure, no problem. She allows the police to enter. There's 3 officers, and she takes them to Orozco's room, opens the door and says, he's in there. Now remember, it's 4 a.m., so this guy's sound asleep in his bed. Police officers enter his bedroom and start interrogating him. He's still in his bed, presumably, partially dressed. One of the officers actually sits on his bed while he's in it. One of them is standing up, kind of pacing around the room, and one is in front of the door. So these are armed, uniformed police officers. You're sound asleep in your bed. The next thing you know, a police officer's standing there. Then he sits down on your bed and he's talking to you about a crime that's been committed. And it's not just the officer talking to you. One's kind of pacing back and forth, and one's right in front of the only door to your room. So this case goes to the Supreme Court to answer this question about Miranda ruling, right? Because Miranda's ruling said, if you are in custody, you are entitled to the Miranda warning before you're interrogated. So these police officers, they don't give him Miranda warning. They don't explain any of his rights to him. They just come in and start questioning to him. So the police argue, well, he's not entitled to Miranda. He's not in police custody. He was in his own bed, in his own bedroom. So how could he possibly say he's in custody and therefore entitled to the Miranda warning before he gets interrogated? Well, his defense attorney's argument was, okay, he may not have been technically arrested. No one put handcuffs on him or said, you are under arrest. But let's ask this. Was this guy free to leave when he's woken up in the middle of the night and police officers are hammering him with questions? Does he feel like, I have constitutional rights. I don't have to stay here. I can just get up and walk out of the room. Well, of course he doesn't feel free to leave. Nobody would. It's not reasonable to him to think he wasn't in custody, that he could just get up and say, I'm not talking to you, and walk out. So this is where the court sort of starts to develop, well, what does it mean to be in custody? Of course, we know if they say you're under arrest, you're in custody. Done deal. But what if police are interrogating you, hammering you with questions, and you're not under arrest? Could you still be in custody? And what the Supreme Court said in this case was, absolutely. you can be in custody and entitled to the Miranda warning before an interrogation begins, even if you're in your own bed, even if you're out on the street, even if you're in the mall. There's a million places you could be where if one police officer or more than one police officer starts questioning you, you could feel reasonably, I'm not allowed to just walk away. And if that's how you feel, then you are in custody and you are entitled to the Miranda warning before an interrogation begins. And this is a great case because it's kind of an extreme example, but you could be in custody in your own bed or at the mall or on the street or on your porch, even without the police saying you're under arrest. So the court decided in favor of the defendant and ruled he was not free to leave his bedroom. Therefore, he was in custody and entitled to the Miranda warning before interrogation. So we know you can be in custody and without the police saying you've been arrested, without having handcuffs on you, and being somewhere out in the community. Well, here's the reverse situation. So if you're in a police station, does that automatically mean you're in custody just because you're surrounded by police officers? So check out what happened in this case. This is a decade after Miranda. So this woman's house gets robbed, and she calls the police, and the police are talking to her about the robbery. And they say, while they're conducting their investigation, can you think of anybody who would have done this? Does anybody come to mind you think might have been involved with your house being robbed? And she says, well, yeah, actually, my son has this friend whose last name is Mathiasen, and he might be involved with this. He may have something to do with this. 25 days after the burglary, the police officer leaves his business card on Mathiasen's door. And on the business card, he writes, give me a call. I want to discuss something with you. So 25 days after the burglary, the officer leaves his business card on Mathiasen's door and says, hey, I just want to discuss something with you. Well, the next day, Mathiasen takes the business card, calls the officer and says, hey, I got this card on my door. I don't know what you want to talk about, but what's up? And the police officers say, I just want to talk to you about something. You're just 2 blocks down the street. Would you mind coming down to the police station? Mathiasen says, sure, no problem. I'll come down now. So he goes to the police station. The officer meets him at the front door, and the first thing the officer says is, you're not under arrest. You are not under arrest. Oh, no problem. I'm happy to help out. What can I help out? They shake hands. They go into a room and start talking. Well, while they're talking, Mathiasen says something that incriminates him about the robbery. So he says something that makes it look like he was involved with that robbery. The police say, thank you so much for coming in. Thank you so much for talking to us. They let him leave. And then he gets arrested later on. So the question here is, well, wait a second. He's in a police station with police officers. The whole building's full of police officers. Weren't they required to give him the Miranda warning and say, look, I'm glad you came in to talk to us about this robbery we're trying to get solved, but just so you know, before you say anything, you have certain rights. And then read him the Miranda warning? Weren't they required to do that? He's in a police station. And what the Supreme Court said was, no, the Miranda warning was not triggered. He was not entitled to a Miranda warning because he was not in custody. You go, well, wait a second. How could you not be in custody? The guy's in a friggin' police station. And the Supreme Court said, yeah, here's the difference. He was free to leave. The police didn't handcuff him and bring him down to the station. The police didn't go get him to his house and drive him to the station. This guy voluntarily came to the station. And he knew he wasn't under arrest because the very first thing the officer said to him was, you're not under arrest. So the court said it's reasonable for Mathiasen to have known he was free to leave at any time. And if you feel free to leave at any time, you are not in custody. If you are not in custody, you are not entitled to the Miranda warning. So in the case where the guy is in his own bed and the police come in and question him, the Supreme Court determines he's in custody, even though he's in his own bedroom because he's not free to leave. On the opposite end of the spectrum, in Mathiasen, the Supreme Court said, yeah, you could even be in a police station and not be in custody. So always go back to the same analysis. Miranda is required. Another way to say that is the Miranda warning is triggered when a person is in custody and before they're interrogated. You could be in custody in your own bed. You can not be in custody in a police station, right? So this is a case-by-case circumstance analysis, what we call totality of the circumstances. So let's go back and specifically narrow in on the Fifth Amendment for a second. So the Fifth Amendment contains our protection against self-incrimination. That is the same thing as the right to remain silent. You can say either one. You can talk about your right to remain silent. You can talk about your protection against self-incrimination. Means the same thing. What it means is that you have the right to remain silent after you have been arrested. Remember, the name of our chapter is Constitutional Rights After Arrest. You have the right to remain silent after you've been arrested. To invoke or to use your right to remain silent, you, the person who's been arrested, is required to state verbally or in writing that you do not want to talk or that you wish to remain silent. So it is up to the arrested person to inform the police, I want to remain silent. I do not want to talk. So for example, if the police say, hey, do you want to talk to us about what happened? The person who was arrested must say no, or otherwise unequivocally, without question, explain that they are using their Fifth Amendment right to remain silent. It's on the arrested person. It's their responsibility to tell the police, I'm not talking. I don't want to talk. I'm using my Fifth Amendment right to remain silent. So let's look in a situation. I want you to picture someone who's arrested, who's in a room in a police station with a police officer and the door's shut, and they're in there talking. What if the person who's been arrested just folds their arm across their chest and doesn't say anything? The police officer saying, were you there? Do you know anything about it? Did you have a gun? Did you drive them to the store? Did you know they were going to rob it? Whatever the police officer's saying, the person who's arrested just sits there with their lips sealed, not saying a word. Is that invoking your right to remain silent? And the Supreme Court has said, no, it's not enough for you to just sit there. You know how Bart Simpson would always put his hands over his ears and go, la, 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 I'm not listening to you, right? That's not invoking your right to remain silent. Just sitting there and not saying anything is not communicating to the police that you are invoking your Fifth Amendment rights to remain silent. You have to say it, and it has to be clear. It has to be unequivocal, meaning there's no doubt that you are invoking your right. And the Supreme Court has upheld that numerous times, that the responsibility is on the person who's been arrested to clearly, without question, communicate to the police that they are invoking their right to remain silent. Once they've done that, they said, I want to remain silent, however, whatever words they use, police got to stop talking to them. And if you watch First 48, well, we'll talk about that in a minute. You get to see this happen a lot. So what is our protection from self-incrimination? What does it really mean? What does it really protect us from? The Fifth Amendment protects you from the police forcing you to give a self-incriminating verbal or written statement. Remember, back in the day, we talked about the police in Britain torturing people and forcing them to consent. Or to confess, or threatening to kill their family member or burn their house down unless they confess. And of course, they didn't do it, but they would just say it just to prevent the consequence, say, I did it. So the Fifth Amendment is trying to protect you from the police forcing you or coercing you into giving a verbal or a written statement that connects you to the crime, okay? So a statement is incriminating if there is a substantial and real threat that the information disclosed, one, may lead to a criminal charge, or two, could establish a link in the chain of evidence that leads to a criminal charge. So if somebody says, do you like Coke or Pepsi better? And you say Pepsi, well, that's not incriminating. That doesn't connect you to any crime. That's just a personal preference, right? So it doesn't cover any possible words that could come out of your mouth. It only covers those words or statements that can connect you to a crime, either directly or indirectly. So let's talk about incriminating statements that could lead to a criminal charge. I sold cocaine. If you're being interrogated by the police and you say I sold cocaine, they can definitely charge you for that, right? That's incriminating. We shot the clerk in the store. John and I stole the jewelry and pawned it. When I went into the bank, I acted like I had a gun and demanded money from the teller. I stayed in the car. Maria was the one that robbed the gas station. I just drove, right? So all of these statements directly relate you to a crime and can result in you being charged with a crime. So these are incriminating statements. So this is what the Fifth Amendment is trying to protect you from doing without knowing all of your rights. And they want to protect you from the police pressuring you and coercing you into saying these things. And you think, well, why? Like, if a guilty person did it, why can't the police lean into them? Well, for investigations, they can, right? Police are allowed to question you. They are allowed to conduct investigations. But what the Fifth Amendment, its really primary purpose is trying to enforce that the prosecution has the burden of proof. Remember, we have a presumption of innocence. I don't care if you are on video waving a sign in one hand with your name on it with a gun in the other while you shoot someone, and that's on videotape for us all to see. You are presumed innocent until proven guilty, no matter what the circumstances are. That's how far the framers of the Constitution went to protect us from the nonsense that went on back in Britain, right? Remember all those things we talked about people were forced to go through. So our system is set up to make the prosecution prove its case. So they're not allowed to pressure you into saying something incriminating unless you know and understand your rights. And that's one of the purposes of Miranda. That's why it's real hard to talk about the Fifth and Sixth Amendment and Miranda separately. It all kinds of folds in together. So if the police arrest you and read you the Miranda warning, you are now on notice that anything that comes out of your mouth can be used against you, right? Because that's part of the Miranda warning. Anything you say can be used against you in a court of law. So that's your warning. That's your warning to say, stop talking, don't say anything, right? If you've heard that right read to you and you say, I don't care, I want to tell them what happened, and you start saying things like, I sold the cocaine, we shot the clerk, Maria's the one who robbed the gas station, I just drove, well, guess what? You're going to be charged with those crimes, and they're going to use your statements against you, and they're allowed to do that. The other part of incriminating statements is not a direct thing, not like I shot that guy or I stole her cell phone. That's one way to have an incriminating statement. Others can be much more vague. It could be any statement that you make that connects you to a crime. And I can't really give you examples because it covers like a million things. So for example, let's say last night a Stewart's in Troy was robbed. And the police say to you, where were you last night? You saying where you were could connect you to a crime, right? If you say you were a block away from that Stewart's or in the Stewart's, just saying that could be incriminating. Asking you where you were, asking you who you were with, asking you if you called someone on your phone, asking you if you got a text from someone. All of these questions could lead you to say something that's incriminating. So it's not just, I shot the person, I sold the drugs. It could just be you saying where you were last night, or who you got a text from last week, or what that text said. So it can cover an awful lot of things. Now remember, somebody asks you whether you like Coke or Pepsi better. Well, that doesn't connect you to a crime. But lots of things you say could connect you. And remember, you don't know what the police know when they're questioning you. So an incriminating statement is anything that directly connects you to a crime, or anything you say that could be used to connect you to a crime. So we know that statements, verbal or written statements, can be incriminating, and the police cannot force you to incriminate yourself. So if they read you the Miranda warning and you choose to talk anyway, well, they can use anything you say that incriminates you against you. But what about other things that incriminate you? Let's apply that analysis to situations that happen all the time. So this guy's driving and he's swerving all over the road, and the police officer pulls him over. He says, "Get out of the vehicle. I'm going to give you a field sobriety test. I think you've been drinking or using drugs." So the guy says, "Okay." And he walks, toe to heel, close your eyes, touch your nose, stand on one foot, point the other toe, and count to 30. He does all the tests and he fails miserably. Can't do any of them. So the officer says, "Blow into this breathalyzer." Remember, they always say, keep going, keep going, keep going. So that trying to get that air at the bottom of your lungs. And the breathalyzer says he has a 0.17 blood alcohol concentration. That's way over the legal limit. So then the officer arrests him for DWI. Well, what is he going to use as proof that this guy was drunk? Well, he's going to use he couldn't stand on one foot and count to 30. He couldn't close his eyes and touch his nose. His breath had X percentage of alcohol concentrated. Well, aren't those all incriminating things? Didn't the officer force him to incriminate himself? If the guy was just sitting in his car, how can the officer arrest him from DWI? The only reason he can get arrested for DWI is all the things the police officer forced him to do. He forced him to give evidence against himself. Well, isn't that self-incrimination? Think about that. Let's look at another situation. The police suspect a woman has committed a murder and wants to determine if her DNA matches DNA found at the crime scene. An officer obtains an arrest warrant for her for the murder. She's arrested and brought to the station. So she's in custody, and they want to interrogate her about this murder. And she says, "I am invoking my Fifth Amendment right to remain silent." She unequivocally informs the officer she is exercising her Fifth Amendment right to remain silent. So the police do what they're required to do, and they stop interrogating her. They stop asking her questions about the murder. But they also say, "Open your mouth. We're going to swab for your DNA." And she opens her mouth, and the police officer puts a thing that looks like a long-stemmed Q-tip in her mouth, wipes it around the insides of her mouth, and sends it to a lab for analysis. Well, if that DNA sample matches the DNA at the scene, didn't they force her to incriminate herself? What's the evidence? The DNA they forced out of her mouth. Well, aren't you protected from being forced to give the police information that incriminates you? Hold that thought. Let's look at another situation where this comes up. Let's say the manager of Stewart's calls 911 and says a robber just came in and held a gun to my head. When the police arrive, they see a man wearing a mask. He's got a long sleeve shirt on, and he's running from the store. He's arrested on probable cause that he's the one who just committed the armed robbery at the Stewart's. When the police are talking to the manager, he says, "The guy with the gun has this really distinctive tattoo on his arm of a clock. I remember seeing a tattoo of a clock on his arm." So they arrest the man, they take him down to the station, and they read him the Miranda warning. They have to, right? He's in custody, and they're about to question him about the armed robbery. So they do the right thing and they read him the Miranda warning. He says to the police, "I'm not talking to you until my attorney is present." Unequivocally says that to police, "I'm not talking to you. I'm invoking my right to remain silent." So the officer stops interrogating, but he says to the guy, "Pull your sleeves up." Because remember, the manager told me he's got this weird clock tattoo on his arm. So the cop says, "Pull your sleeve up." And the guy says, "No, I'm not pulling my sleeves up." So the officer leans over and pushes his sleeve up his arms. Then the officer sees this tattoo with a clock. Well, what's going to incriminate him? The fact that he was identified as having this clock tattooed, and that connects him to the armed robbery. So didn't the police force him to incriminate himself by pushing his sleeve up to see if he has this tattoo? The tattoo is incriminating. Doesn't that violate this guy's rights against self-incrimination? Well, the answer to all three of those questions, the questions about the DWI field sobriety test, the test about the DNA swab, and pushing up somebody's sleeves, all brings us to this slide, which lets you know that the Fifth Amendment protection from self-incrimination does not apply to non-testimonial evidence. Your right against Fifth Amendment self-incrimination, protection against self-incrimination, is about statements. Statements. It does not apply to a handwriting sample. Well, why the heck would it apply to a handwriting sample? Let's say somebody gets kidnapped and the kidnappers leave a ransom note. And the police arrest you for that crime, bring you down to the police station. And they want to interrogate you about this kidnapping and this ransom note. And you say, "I don't want to talk to you. I don't want to say anything. I'm invoking my right. I want my attorney." And the officers say, "Okay, we'll stop questioning you. Here's a piece of paper. Write down, you must leave $10,000 in a bag by Friday behind the Walmart. Write that down on a piece of paper." And you go, "Well, wait a second. I'm protected against making statements against myself." Well, the Supreme Court has said that's not a statement. All you're doing is allowing the police to look at your handwriting. So if the police ask you to do that, you're required to do it. And if you say, "Heck no, I told you I'm not talking to my attorneys here. I want my attorney present before I make any statements," you're required to give them the handwriting analysis. And if you refuse, when you go to trial, the police can say, "We asked him to give us his handwriting sample and he refused to do it." And they can use that against you. Fingerprints. Police take fingerprints a lot, right? Fingerprints can be used against you, even if you've invoked your right to remain silent or your right to have your attorney present. If you've been arrested and read your Miranda warning, the police can require you to appear in a lineup, right? We don't see this too much anymore, like in old movies. You see people actually standing up against a wall and they bring a witness in and the witness says, "It's number 3. Number 3 is the guy who committed the crime." You don't see that too much because now they put your photo in a lineup. If you watch First 48, you see that all the time. The police officer prints out 6 photographs. They're different people. It doesn't matter who they are, except one of those photos belongs to the person that they suspect of committing the crime, right? They want to see if the witness will point out the person that you've investigating, right? Well, that's incriminating. If somebody points to your picture in a lineup or points to you in a lineup and says, "That's the guy, that's the girl," well, that's incriminating. Doesn't matter. The U.S. Supreme Court says if you've been arrested and you've been read your Miranda warning, whether or not you've claimed your rights to Fifth and Sixth Amendment to remain silent or have your attorney present, you can be required to appear in a lineup. Again, if you refuse and say, "I'm not doing it," well, they can tell the jury about that at trial. Try on clothes. This sounds a little silly. Why would the police officer ask you to try on clothes? Well, to see if they fit, right? So if a sweatshirt is left at the scene of a crime, a glove, very famously in a case some years ago, left at the scene of a crime, the police can require you to try it on. They can say, "Put those pants on over your pants. Put that sweatshirt on. Put that coat on." And then they can make you wear it in a lineup. That's something, huh? course, walking in a straight line, standing on a foot, counting 20, touch your nose, that's all the DWI field sobriety test. The police can require you to do that. DWI don't even have to give you Miranda rights. That's a whole nother class. DNA sample, where they swab the woman's mouth after she asked for have her rights invoked and not communicate with the police. They're allowed to do the DNA sample. Showing your tattoos or scars, you're required to do that, even if you've invoked your rights. And of course, taking and showing your photograph. And if the police ask you for any of these things after you've invoked your rights and you say, no, I already told you, I'm not giving a statement and I don't want to talk to you or do anything else until my attorney's here, and you refuse to do any of these things or provide the sample, then that can be used against you. And you say to yourself, wait a minute, you've been saying for half an hour, the police can't force me to incriminate myself. Well, you've got to remember that the protection against self-incrimination is about statements. It's about statements, not DNA, fingerprints, trying on a shirt, counting to 20, DNA sample, or let me see your tattoo. So let's just review again because it's really important, not just for your final exam, not just for quizzes, but for every criminal justice course you ever take, that you know when the Miranda warning is triggered. So the Miranda warning is triggered when a person is in custody and before they are interrogated. Once the suspect has clearly stated they want to remain silent, or they've clearly stated they want an attorney, the interrogation must stop immediately. Remember, they can still do the DNA sample, the handwriting sample, they can still do all that stuff, but they have to stop questioning you about the crime. So, on live PD, have you ever seen a person get arrested, but Miranda rights are not read? Right? There's a couple different reasons for this, and we talk a lot about this in substantive criminal law and criminal procedural law. So let's go back to that guy who gets pulled over for swerving around, and the police smell alcohol on him and make him do the test. Not only are they allowed to do that, they don't read you your Miranda warning, right? So when they take that guy out of he's sitting in the driver's seat, they don't say, okay, before I ask you to get out, let me read you that Miranda warning. They just say, get out of your car, stand on your foot, hold your finger out. They just start giving orders, right? They don't give you your Miranda warning. You've never once seen that on TV where they give a Miranda warning before they do the field sobriety test. And the reason is they're not required to. The Miranda warning does not apply, is not triggered by routine traffic stops. So that is an exception to the Miranda warning. So if you get pulled over for going through a red light, driving up onto the curb, speeding, swerving, talking on your cell phone, throwing trash out the window, whatever thing you did, the police are not required to give you your Miranda warning to process a routine traffic stop. So if you watch Cops or Live PD, you'll see cop after cop pulling over driver after driver, and you don't hear a Miranda warning. That's why routine traffic stops do not trigger Miranda. The exception is if you actually get arrested for the routine traffic stop, right? So once they've done all those field sobriety tests and the officer says you're now under arrest for DWI, that's when the Miranda warning triggers, after you've been arrested. The whole time the cop's talking to you, let me see your driver's license, your registration, doesn't trigger Miranda. There's another reason why you don't see Miranda get read on those shows where you're watching people get arrested. And it has to do with interrogation. So those shows, Cops, Live PD, even First 48, where you're watching people actually get arrested, a lot of times they're not getting Mirandized right out on the street or on their front porch or wherever they're getting arrested. And that's because the police aren't going to interrogate them, okay? So imagine this situation. Two guys are on the street getting in a full-out brawl, beating the crap out of each other. The cops pull up, they pull them apart. They say, you're under arrest. Put them in the police car. Well, the Miranda right hasn't been triggered yet because the cop's not talking to him. The cop's not asking him about the fight. The cop just saw him fighting, put him in handcuffs, and put him in the back of the police car. He's not required to read the Miranda warning because he's not interrogating him. The cop's like, I already know everything I need to know. I can testify in court that I saw this guy beating on this other guy. And that's all the cop needs. He doesn't need to question you about the crime. So he can bring you back to the station, process you, and put you in jail without ever reading you your Miranda rights because he didn't interrogate you. So remember, just being in custody does not trigger the Miranda warning. It's that you're in custody and the police are going to interrogate you. If the police are not going to question you or talk to you, they don't have to give you the Miranda warning. Now, good practice is just read the person you just arrested their Miranda warning, whether you plan on talking to them or not. So let's see this situation play out. Two guys are brawling in the street. Cops show up. They grab one of the guys. This officer has his guy. He arrests him for assault, disorderly conduct, whatever the charge he decides fits that situation. He says you're under arrest. He puts him in handcuffs. He puts him in the back of the police car. Doesn't say anything else to him. Doesn't have to, right? Because he's not questioning him. So they get in the police car, and the police officer's like, I'm not going to talk to this guy. I know everything I need to know. I don't have to give him Miranda. But the guy in the back seat with the handcuffs on starts talking. That SOB threatened me, blah, blah. And he starts talking. And the police officer starts responding. Well, why'd you punch him? Why didn't you just go home? Why didn't you call us? Well, now we're creating a sketchy situation, right? Because if this guy says something, yeah, I punched that SOB, blah, blah, blah. Well, he just incriminated himself. And the police can't use that statement because the police officer did not give him the Miranda warning. If the police are going to talk to you about the crime and you say something, they can't use it if they didn't give you the Miranda warning. So if the police arrest you and don't talk to you, they're not required to give you the Miranda warning. Okay? I wish we were live. I wish we could talk about this because I know you guys would come up with great scenarios we could talk about. So let's just do a little review here. Invoking your Fifth Amendment right to remain silent and or your Sixth Amendment right to have an attorney present with you. It must be unequivocal. It must be without question. It must be clear. To invoke your Fifth Amendment right, you could say something like, I want to remain silent. I am not going to talk to the police. I want my Fifth Amendment rights. I plead the Fifth. You can say any of those things. It doesn't have to be just one of those four things, but that's how clear it has to be. It has to be unmistakable that you are invoking your right to remain silent. For the Sixth Amendment, you could say something like, I want an attorney, get me a lawyer. I won't talk unless an attorney's here. Call my lawyer. Okay. If you watch First 48 First 48, and they're questioning someone, and it's really interesting because you get to actually watch the police question someone who's just been arrested. Even if they've had the Miranda warning on the way to the police station, the officer may do it again, right? You can't read it too many times. So if you're not sure the other officer read them, you're not sure the guy responded, go ahead and read them again. You're going to question this person. Make sure they've had their Miranda warning. If they sit there and don't say a word, the police can keep questioning them, right? So that person needs to say, I'm invoking my Sixth Amendment rights. They don't have to use those words. A lot of times when you watch First 48, they'll say, I want a lawyer. That's plenty. That's all they have to do. The second they say that, questioning them about the crime has to stop right then. So why is this so important, right? If you didn't do anything wrong, or you're not worried about talking to the police, why do you even need to invoke your rights? Why don't you just sit there and keep your lips zipped shut and not say anything? Well, here's an important reason people shouldn't do that. There was a study done a few years ago that said and they looked at thousands of people's cases who'd been arrested. And they found of all the people they looked at who were interrogated by the police, 42%, almost half, ultimately confessed to a crime. And what they found was the most powerful factor is the suspect's belief that the police have evidence implicating him or her in a crime, such as fingerprints, hair, or blood evidence. So what does this look like? Somebody gets arrested, they're taken to the police station, put in a room, sat down, officer comes in to interrogate them. They've got to be read their rights. Even if we think they understand them, even if the person's been involved in the criminal justice, doesn't matter. Police officer reads them that Miranda warning and tells them, you have the right to remain silent. Well, why shouldn't you just sit there? Don't say anything. Don't even say, I want to remain silent. Just sit there with your lips zipped. Well, part of the problem is the police can start hammering somebody because they haven't invoked their rights. Remember, if you just sit there with your lips zipped, you haven't invoked your rights. So the police can keep talking to you. And the study found if the police say to somebody who's in custody and been arrested, look, we've got your fingerprints at the scene. We found your blood evidence at the scene. We already talked to your roommate and he said you did it. We already talked to the victim and the victim identified you. If the police start saying that sort of stuff to someone in custody, almost half the time that person responds by confessing, right? Now here's the catch. Is it legal for police to just outright lie and say they have all that evidence when they really don't have it? And the answer is yes. The Supreme Court has repeatedly upheld the police outright lying to you during an interrogation and telling the person who's been arrested they have all kinds of evidence that they don't have, right? They're allowed to do that. So, person in that room's been arrested. They say, I want to invoke my right to remain silent, however they say it. They say, I don't want to talk to you till my lawyer's present, however those words come out. The police have to stop talking to that person about the crime. That stops them from saying, we have your fingerprints. We've got video of you going into that house. They're no longer allowed to talk to that person about the crime, so they're no longer allowed to talk to them about evidence they may or may not have. And that's really important to stop the police from talking, because studies have shown if the police keep talking, that person's going to confess to something. Okay? So, but remember, the Supreme Court has ruled it is on the arrestee. It's their responsibility to invoke their rights. If they don't invoke their rights, the police can keep talking to them about the crime. They can tell them they have evidence against them. They can even lie and describe evidence they have against them that doesn't exist. All right, so let's say the person has invoked their right to remain silent, or they've invoked their right to counsel. They have said unequivocally, I want to remain silent, or I'm not talking to you till I have an attorney. The police have to stop talking about the crime, but they don't have to stop talking entirely, right? The police can still talk to an arrested person who's invoked their rights about things unrelated to the crime, okay? They can ask the person, are you hungry? Do you want a drink of water? Do you need something to eat? Do you need to go to the bathroom? We can take you down to the bathroom in a couple of minutes. Are you on any medications? If this person's going to jail, it's really important that the people who run the jail know if you take any medications, if you have any medical problems, so they can address that if it comes up. So, of course, the police are allowed to say to you, do you have any medications? Are you having any medical problems? How do you feel right now? Okay? They're allowed to discuss all that because none of those questions relate to the crime. So the police are allowed to have all those conversations with you. That does not violate your rights. But we had a case, pretty famous case, where it got real sketchy with the police talking to somebody after they'd had their rights invoked. This case is in your textbook on page 368. Back in the late 70s, in Des Moines, Iowa, and you can see on the map Des Moines just about in the center of the state there. What happened was a child was murdered a few days before Christmas in Des Moines. And a teenager saw this guy, Williams, taking a body out of a building that was wrapped up in a rug. And he told the police that. I saw Williams taking a body in a rug out of this building. I saw that with my own eyes. Once he's identified as the murderer, the police go to get a warrant for his arrest. But in the meantime, Williams splits and he flees to Davenport. And you can see Davenport way on the eastern side of the state. It's about 170 miles away from Des Moines. So the police have an arrest warrant. They're looking for him, but he took off. While they're looking for him, an attorney calls the Des Moines police officers and says, look, I have a client, Williams. I know you're looking for him. We know you have an arrest out warrant for him. We want to cooperate. So he's in Davenport, and he's willing to turn himself into the police station in Davenport. He will come in willingly and let you arrest him. But you're not to question him about the crime. He has invoked his right to counsel. I am his counsel, and I'm telling you, he is not to be questioned about the crime. He's willing to come in willingly and get arrested. Go ahead and put him in jail. Do not interrogate him. He is invoking his rights. The police in Des Moines say, no problem. If he will turn himself in, we will not question him about the crime. The police in Davenport say, if he comes in and voluntarily submits to arrest, we will not question him about the crime. Now, the attorney knows that the police are going to drive him back to Des Moines. So they're going to be in the car for a couple of hours with him. So the attorney specifically says, look, I know you're going to be in that car with him for hours, and I can't be there. So just know, I'm telling you again, he's invoked his rights to remain silent. Do not question him unless I am present. The police who are going to drive him back to Des Moines say, no problem. We will not talk to him about the crime. So during this couple-hour drives, there's an officer driving, there's an officer in the passenger seat. The officer in the passenger seat starts talking. Now remember, officers are allowed to say to the guy in a couple-hour drive, do you need to stop to go to the bathroom? Do you need something to eat? Are you feeling it? They're allowed to do all that, so it's okay that they're talking. But this is what the officer starts talking to him about the situation. And every time the officer even hints about something to do with this crime, Williams says, when we get back to Des Moines and see Mr. McKnight, that's the attorney, when we get back and he's there, I'll tell you everything. I'll tell you everything. But I can't talk until Mr. McKnight, my attorney, is there. So the police officer should have stopped talking to him about the crime, but he doesn't. And the police officer starts doing what has been famously termed the Christian burial speech. You will see that in case law. And what the officer started doing was he said, do you believe in God, Williams? Are you a Christian? Williams says, yes, in fact, I am. The officer says, look, you can tell it's snowing, it's sleeting, it's freezing rain. We're going to get a couple of inches of snow by the time we get back to Des Moines. And this little girl's body is out there. We know it's out there. And if we get a couple feet or inches of snow, we're not going to be able to find it. And here we are, just a couple days from Christmas, and her poor family, her poor parents are mourning, are devastated because their daughter has been murdered. And the least you could do for them, the very least you could do, is tell us where the body is. So this little girl could get a Christian burial, and her parents can at least bury her and know where she is right before Christmas. At least that could happen. But if it keeps snowing, we're not going to be able to find the body. Trust me, dude, we got people out looking for it for over a mile spans, trying to figure out where you dropped this body. But if this snow keeps up, we're not going to be able to find it. So the least you could do is tell us where the body is. And you know what happens? Williams takes them to the little girl's body. He says, okay, I'll show you where the body is. Now, do you think that's incriminating? What's more incriminating than taking the police to where the body is? Because the only person who knows where that body is the person who put it there. This is the ultimate incriminating statement. So Mr. Williams, despite all this, is convicted and his case goes all the way up to the Supreme Court. And the prosecution argues, well, they weren't questioning him about the crime. They were talking about a Christian burial. Really? Are you kidding me? And the Supreme Court ruled that, in fact, Williams' rights were violated because the attorney himself had told them he was invoking his right to remain silent. The attorney had told him that Williams was not to be questioned until the attorney was present. And on the drive, Williams himself said several times, as soon as we're with my attorney, Mr. McKnight, I'll tell you everything. So the officers absolutely violated Williams' right to the Fifth and Sixth Amendment. You want to know what happened in that case, you have to read about it or take criminal procedure. We talk about that a lot in there. All right, we're going to move on to a little different topic here. The Fifth Amendment contains our right to remain silent. It also contains the passage about the grand jury. And what it says is, no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. Well, what the heck does that mean? We hear, people talking about grand juries, and a lot of people don't know a lot about it. There's a reason for that. So there's really two types of jury duty. We don't talk about this in these terms, but the textbook uses these terms, so I want to cover them. The jury talks about a petit or a petite jury and a grand jury. So a petit or petite jury is a trial jury. That's where you go and sit with all the jurors, and the prosecution presents their case and the defense presents their case, and witnesses are called and evidence is submitted, and you sit there as a member of the jury. That's one kind of jury duty. The other is a grand jury, and that is a very different thing. What happens when you get called for jury duty? And I wish we were live together so we could talk about this, because some of you probably have been called for jury duty. What you do is you get a notice in the mail that says, hi, you have to report for jury duty. This is a legal requirement. You are actually required to report. If you keep blowing off your jury duty, you can actually get arrested for that. So don't ever blow off your jury duty. Sometimes the card you get in the mail will instruct you to call a phone number. And you'll call the phone number and you'll be told whether you have to report or not. Sometimes you'll call and they'll say, nope, you're all good. You don't have to report, and you're done. Sometimes when you call, or the card will just order you to go to the courthouse on a date and time, and you need to go. And what will happen is you'll be in a room with anywhere from 30 to 60 people. Everybody's on their cell phone, reading the paper, doing whatever it is they do to keep occupied. And someone comes in and starts bringing out groups of jurors, and they're identified by number. So they'll say, okay, I need jurors number 35 to 50. And if that's your number, you got to go with them. If you're being considered for a trial jury or a petit or petite jury, all the same thing, you're going to go into a courtroom and the attorneys are going to question you. The defense attorney is going to be there, and the defendant could be there, and the prosecutor is going to be there, and the judge is going to be there. What they're going to do is they're going to ask you tons of questions. Where do you live? How old are you? What do you do for a living? Do you go to school? Where do you go to school? What do you study? What are your hobbies? They can ask you all these questions. And based on your answers, they're going to figure out if they want you for a jury or not. That's one kind of jury. The other kind is a grand jury, and that's a very different thing. If you are a juror for a regular trial, you are only a juror for that case, that particular defendant, and that particular crime. When you're called for a grand jury, what they do is they have you participate in a proceeding, and you're going to have to show up for months. It'll be like every Tuesday from noon to 6 for the next 4 months or 3 months. And what's going to happen is you're going to be in a room with the other members of the grand jury. It's usually 16 to 23 people. And it's you, the members of the grand jury, and the prosecutor. There's no defense attorney, there's no judge, and the defendant is not there. It's the members of the grand jury and the prosecutor. And what the prosecutor does is says, this crime was committed on this date. We think this person did it, and we're going to show you the evidence that we have against this person. They're going to call witnesses in, could be the police officer, could be the victim, could be an eyewitness, could be somebody who knows something about the crime. And without the defense attorney there, without the defendant there, without the judge there, these witnesses are going to say what they know to the members of the grand jury. And when all the evidence is in for that case, the grand jury is going to decide whether the person, the suspect, is indicted or is not indicted. If they are indicted, they issue what's called a true bill. It's a funny old expression, a true bill, which means that person has been indicted by the grand jury, which means that person is going to have a trial, and they are going to be on trial for that crime. The other thing the grand jury can do is say, nope, sorry, you don't have enough evidence. We're not indicting this person. And that person's not having a trial, okay? So the odd thing about grand juries is they are held in secret. The press is not allowed to come. The media is not allowed to come. You're not allowed to come. A student is not allowed to go and even just observe. The defendant is not permitted to sit there and learn about what evidence is going to be presented or to question witnesses. All those rights I told you that people have don't apply to a grand jury. Very interesting, right? Grand juries are very controversial topics for this reason, because it is literally one-sided. It's the prosecutor presenting their case, which means no one gets questioned, no one gets cross-examined, no one gets kind of put to the test of what they know. Doesn't happen. And there's a very old corny expression called, you could indict a ham sandwich, right? It's so one-sided, the prosecutor can go in there and say just about anything and get somebody indicted, right? Very controversial topic. We could take a whole class in grand juries and why we have them and their usefulness and why we still have them. But it's a constitutional right that if someone will be held to answer for a capital or infamous crime, to us that means felony, right? We don't do grand juries for parking tickets or for smoking weed in public. These are for felonies. But it's held in secret with 16 to 23 jurors. The prosecutor presents an indictment, the case against the suspect. Prosecutor calls witness to give evidence about the crime. There's no judge, no defense attorney, no defendant. It is held in secret. People are not allowed to observe. And if you're a member of a grand jury, you are sworn to not disclose to anyone, even your own family members, what you heard or what you learned. You take an oath to not disclose that information. And after the prosecutors presented one case to you and the jury's decided to indict or not to indict, they bring another case and another case. And as being serving on a grand jury for a couple of months, you could hear 10 or 12 cases, different cases. So there's a big difference between jury and grand jury. Petite jury, trial jury, we just call it jury. We don't specify too much when we talk about it. We just call it a jury. That means you're at a trial. That means the prosecutor, the defendant, the defense attorney, the judge, the witnesses, you're seeing everything happen in front of you for one case. A grand jury is a secret proceeding that happens only with the prosecutor. So really important you know the difference between a jury and a grand jury. Discovery. Discovery is a huge topic that we're going to cover in one slide, okay? So during the process of discovery, and it's a process, it's not really a thing, it's a process, the prosecutor and the defense attorney are required to exchange information. So for example, if the prosecutor has a report that says the defendant's DNA was found at a crime scene and it was identified as belonging to the defendant, that report, copy of that report, has to be given to the defense, right? This is an open trial process. The prosecutor has to prove its case, and the defendant has a right to know what they're being accused of and who's accusing them and what evidence the other side has, right? So discovery is the broad, wide term we use to describe the process of the prosecutor and the defense attorney having to exchange evidence and information. That's what discovery is. It's the exchange of information. And if the prosecutor fails, either by accident or on purpose, to disclose something, the judge can exclude it from the trial. So this is very, very serious stuff here, right? The prosecutor has very strict rules about what they have to turn over to the defense, the form it has to be in, the timing of it being turned over. And there's a lot of information about that in your textbook on page 405 and 406. It talks about different discovery items, so you can look at that there. But discovery takes a long time. It doesn't just happen in one day at 2 o'clock on a Friday, right? It takes months. It can take weeks or months because the prosecution has their case, but they could still be talking to people, conducting investigation, seeking out other evidence, waiting for test results. So it could take a while for the prosecution to get all their evidence over to the defense. And the defense is required to turn some information over to the prosecutor. Say the defendant decides they are going to plead not guilty by reason of insanity. And we talked about that a couple weeks ago. Well, they can't just spring that on the prosecution. They're required to submit that information to the prosecution as part of discovery, right? So it happens on both sides. The prosecutor and the defense attorney are required to share information with each other. This can take weeks or months. Pre-trial motions. We talked earlier in the semester and I said, when you see trials and, you're watching Netflix and you're watching a trial, either a real trial or portrayed in a movie, they cut out what is called pre-trial motions. So before the jury comes, before we're all in a courtroom presenting a case, there's this whole process called pre-trial motions. The judge needs to make a lot of decisions about what evidence will be admitted before the trial even starts. Now, there's some things they can debate and talk about in the trial while the trial is actually happening, but a lot of decisions get made before the trial ever happens that the jury never hears about. Because if the jury gets wind the guy's confessed and they're going to exclude his confession, well, we don't want the jury knowing about that, right? So all those decisions need to be made beforehand. So pretrial motions are either written, or they sometimes can be verbal if it's a more minor issue, and it's a request for the judge to either accept or exclude a piece of evidence. So the prosecutor would be arguing his confession should come in. It was voluntary. He was read his Miranda rights. He understood his Miranda rights, and he voluntarily confessed. So we are making a pretrial motion that his confession be admitted as evidence. The defense attorney, of course, is going to argue that he wasn't read his Miranda rights, or he was read his Miranda rights but didn't understand them, or that he was read his rights and he never waived them. He invoked his right to remain silent, but the police got a confession out of him anyway by continuing interrogation. Whatever the issue is, all of that's going to be settled by the judge during pre-trial motions. Another thing that could happen is the judge could be making decisions about the order of the witnesses, who's going to be called first. If there's expert witnesses, how that's going to be handled. If a witness, say a young child, should they be allowed to testify? Are they what we call swearable? Due to the child's age, are they able to be a witness? Do they understand what it means to take an oath and to swear to tell the truth? All that stuff is pre-trial motions. It takes weeks, usually months, and all of that happens before the trial even starts. Change of venue. The venue is the location of the trial. It could mean the city, but it usually means the court. So, sorry about that beep. Apologize for that. So the location of the trial is the Albany County Courthouse. That is the venue. The venue of the trial is the Rensselaer Supreme Court. That is the venue. So it's the specific location where the trial will be held. That's what all venue means. It's the location. So the Sixth Amendment states, a trial must be held in the state and district wherein the crime shall have been committed. Remember, we talked about in Britain being hauled hundreds of miles away from your home and having to be in a trial away from any resources, family, friends, or witnesses, right? So they address that in the Sixth Amendment by saying your trial will be held where the crime was committed. Of course, like we said, not at the crime scene, but in that city's courthouse, in that village courthouse, in that county's courthouse, right? So it's got to be as close as possible to where the crime was committed. However, you can make a motion, like those pretrial motions, for a change of venue. That's just one of the pretrial motions you can make. It's extremely difficult to get a trial moved. It's very expensive to move a trial. Now everyone has to travel, right? All the witnesses have to travel. The police officers have to travel. Now it complicates, the jury. Like it's very expensive to move a trial. So to get a change of venue, the defense attorney must prove to the judge that due to extensive media coverage or some other factor, for some other reason, the defendant cannot get a fair and impartial jury at the location, at the venue where the crime was committed. So it would be saying the crime was committed in Troy, but we can't have the venue be the Rensselaer County Supreme Court because due to extensive media coverage or some other factor, we're not going to be able to get jurors who haven't been totally influenced about what occurred. So they're already going to come in and think the defendant's guilty. And remember, we have a presumption of innocence. So I have to be in a place where I can get jurors who are going to be fair and impartial and haven't been drowned in information in the media about this case. But again, because it's expensive and because of a lot of other factors, it is extremely rare for a judge to change the venue, to change the location of a trial, to have a trial away from where the crime was committed. Now, note that it's not a violation of the defendant's Sixth Amendment rights to move the trial because it's his or her own attorney who's asking for it, right? So you're waiving that right to have the trial there. You're asking the judge to move it. And it's very rarely granted. But we had a local case a few years back where a change of venue was requested and granted for very good reasons. So I'll show you how extreme it is that we change venues. Because remember, if it's just media coverage, we'd have to change every trial, right? There was a shooting in Troy yesterday at noon. It was on the news and on social media within an hour of the shooting having occurred. So the way media is, it's almost impossible to not know or have heard of a crime, right? That's not so much what we're talking about. That's unavoidable. What we're talking about is extensive coverage over a period of months where evidence is being discussed, where witnesses are talking in the media about things. Like it's that extreme sense of coverage. So not just media coverage, but extreme coverage or other factors. And the case of People v. Porco really illustrates well what a different factor would be that would really require the judge to change the venue. You may have heard of this case. Chris Porco grew up in Bethlehem, right in the Delmar area. His father, Peter Porco, was an attorney, a very well-respected attorney who worked for the Appellate Division, 3rd Department. So our first level appeals court, that's where he worked as an attorney. And he had a brother and lived with his parents in Bethlehem, pretty close to the high school there. And Chris Porco was a pretty troubled kid. He had different, run-ins with different criminal activity as a younger person. And then he went away to the school at the University of Rochester. University of Rochester is a very good school. It's a very expensive school. This is, 10 years ago, it was already $31,000 a year tuition. So a good school, private school, very expensive. So he's off at school at the University of Rochester. And he gets kicked out because he fails out. He fails all or most of his classes, and he gets kicked out of school. And the University of Rochester tells him, if you go to another school and get some good grades and bring your grades up, we might be willing to readmit you and let you come back. But based on your performance right now, you can't come back. So he enrolled at Hudson Valley Community College, our own school, and he started taking a couple of classes there to get his grades up and try to get readmitted to the University of Rochester. But he didn't do well in his classes at our college either, and his transcript reflected that. So now he's in a bit of a panic because all he wants in the world is to go back to the University of Rochester. His parents are extremely unhappy that he's failed out. They paid all this money for him to go to school there. They had to take loans out for him to go to school there. And he blows off all his classes, and they still owe all this money. So his parents are extremely upset with him. And he now is basically failing out of Hudson Valley, right? So he gets a transcript from Hudson Valley showing that he's failed, and he forges a new transcript. He, completely forges a new transcript. He submits it to the University of Rochester. They accept it, and they let him come back. Okay? So he's forged his Hudson Valley transcript. Now, his parents don't want to pay his tuition because, remember, they paid his tuition, tens of thousands of dollars. He blows off all his classes, fails out. They tell him, we're not paying for school. He says, no problem. I'll take out loans. I'll pay for it. But in fact, what he does is he takes out a $31,000 loan and forges his father's signature on it. So in fact, his father did take out another $31,000 loan, but without his knowledge because his son forged his name. And all this other stuff is going on. He's stealing stuff. He stole stuff from his employer. Like he's just up committing all these crimes all over the place. And then one day, his father is murdered in their home. His mother is tremendously disfigured. What happened was in the middle of the night, someone came into their home in Bethlehem. The brother's not there because he's in the military. Someone attacked them in their sleep with an axe. Peter Porco was incredibly injured. Mrs. Porco, Chris's mom's eye, her left eye, was actually removed from her head. Her skull was bashed in by this axe-wielding maniac who's trying to kill them. And then the attacker leaves. Peter Porco remained alive for a little while and then died on the scene. That morning, he doesn't go to work, and people are very concerned because he was a great employee and took his job very seriously, and they kept calling and calling and calling the house, and no one's answering. There's no reason he shouldn't be at work. They send a court officer to his home, and what the court officer finds is Peter Porco having been bludgeoned to death with an axe, who is dead on the scene, and Mrs. Porco, Joan Porco, absolutely critically injured. She's as near death as a person can be. The EMS immediately rush her to the hospital. She has multiple surgeries. They have to reconstruct her skull. She completely loses her one eye, and her vision is terribly damaged in the other. She suffered a traumatic brain injury that can't even be suitably described. So the police, of course, start investigating who could have committed this crime, and they ultimately determined that their son, Chris Porco, is the man who broke into their house in the middle of the night and attempted to murder them with an axe. Now, this happened in Bethlehem near Delmar, Albany County. So his trial should be held at the Albany County Courthouse, about 500 feet from the New York State Appellate Division, where his father was a very well-respected attorney. So every attorney in town knows Peter Porco, right? Almost every attorney in town knows Peter Porco's wife. And because of the heinous nature of this crime, it's in the media every day, all day. Information about the scene, who could have, committed the crime. Witnesses are being interviewed all over the place. So Terry Kinlan, who's the gentleman you see in the photo standing next to Chris Porco, is a long-term criminal defense attorney in this area, had many, many high-profile cases. He practiced criminal law for like 30 years. He just recently retired. He represented Chris Porco, and he argued to the court in a pretrial motion that there was no way in heck Chris Porco could get a fair and impartial trial in Albany County. For one reason, there'd been extensive media coverage about all different facts and information and who the witnesses were to this case and what information the police had discovered during the investigation. And his neighbors and relatives and friends are talking in the media about the case. But of course, the other issue is his father worked for the court system for many, many years. And Terry Kinlan argued to the court that in order to have a fair and impartial trial, Chris Porco's trial would have to be moved out of Albany County. And the judge agreed. And they got the change of venue, and his trial was actually conducted in Orange County, right outside of New York City, down south. So the point of this is that change of venue is possible. However, a defendant has a constitutional Sixth Amendment right to have the trial local to where the crime was committed. However, if a defense attorney waives that right, they can waive that right on behalf of their client and seek to have a change of venue, have the trial moved to a different location where people don't know so much about the crime. However, it's rarely granted. And I bring up the People v. Porco case because it's that type of an extreme example where a judge will actually change the venue. It's very rarely granted. This case, there's obviously tons of information out there about this case. 48 Hours, the television show, did a very good broadcast on this case that's still available. So if you want to learn more about this case, I would recommend the 48 Hours episode about it. There was a dramatized movie they made about this. It is horrific. It is inaccurate. It has little to do with the facts of this case. I would skip that altogether. It was terribly done. But there have been some of the shows like Dateline and 48 Hours that have done programs about this case that are very interesting. So we're almost finished. Bear with me. We're about wrap it up here. One of the last things we're going to talk about is selecting the jury. So the jury selection process is called voir dire. It's a French word. It's not something we would normally use in conversation, but the jury selection process is called voir dire. That's all voir dire means, is jury selection process. So like we talked about, many people get called for jury duty. You sit in a room and they question you. Right? This isn't the grand jury. This is selecting a trial jury. So they bring, a group of 10 or 15 of you into the courtroom at a time, and they ask you different questions about where you live and where you work and your hobbies. And do you know the defendant? Do you know any of these people? And they'll give you names of people who are going to testify. Do you know Judy Smith? Do you know Tom Michaels? And you're going to answer, yes, I know that person, or no, I don't know that person. Because what they're trying to figure out, both the prosecutor and the defense attorney, is, are you going to be a fair and impartial juror? If you know the defendant, of course you can't sit on the jury. If you like him, you can't sit on the jury. If you don't like him, you can't sit on the jury, right? If you know or are related to a bunch of the witnesses who are going to be testifying, you can't serve on the jury. If you demonstrate you have preconceived notions about the case, let's say you go in and you go, yeah, I heard all about this case on the news. There's no way this guy committed that crime. Well, the defense attorney wants you on the jury, but the prosecutor doesn't. And if you come in and you say, well, if he got arrested for this, I'm sure he did it. Well, the prosecutor might want you, but the defense attorney doesn't, right? So what they're looking for is people who are going to listen to the evidence and only listen to the evidence and only use that to come up with a verdict. So the voir dire process gives attorneys two ways to get somebody off the jury. One is called a preemptory challenge, and during those pretrial motions, the judge will determine how many preemptory challenges each side gets. They each get the same amount. So they might say, prosecutor, you get 6 preemptory challenges. Defense attorney, you get 6 preemptory challenges. And a preemptory challenge means you get to kick a juror out, and you don't have to say why. You can just say, I'm excluding juror number 17, and juror 17 is out. You don't have to explain why. but you only get a limited number of those, right? Because otherwise the prosecutor and the defense attorney are just going to use those trying to find the one person they think will help them out, right? So you only get to use that a couple of times and the judge decides how many. So a preemptory challenge is a way to eliminate a juror, and you don't have to give a reason. You just say, I don't want juror number 22, and they get excused and go home. The other type of challenge you get an unlimited number of, and that's challenges for cause. And you use a challenge for cause when a person demonstrates they can't be fair and impartial, or they have too much previous knowledge of the case, or they know the defendant, or a lot of times you use a challenge for cause against a person who's been a victim of that same crime. So if you have someone who's being tried for armed robbery, you don't want a juror who's been the victim of an armed robbery, right? Because they're going to have feelings about that have nothing to do with the case. So a preemptory challenge, you only get a specific number of them to get rid of a juror for no reason. Don't have to give a reason. You get an unlimited number of challenges for cause because those challenges are made because there's a legitimate reason, a reason you can articulate and describe as to why that juror is not appropriate to serve for that trial. Confrontation clause. The Sixth Amendment gives us the right to be confronted with our witnesses. Remember, way back in the day, you didn't even get to know who accused you. And if you did know who accused you, you weren't allowed to ask them any questions. You weren't allowed to challenge what they were alleging against you. So the Sixth Amendment gives us the right to confront witnesses, and it's called the Confrontation Clause. That just makes sense. So the defendant has a right to know who's accusing them of committing a crime and the right to question each witness. So they don't just get to question the victim, the person who said they committed the crime. They get to question every witness who's giving information against them. And we call this cross-examination. So if the defendant is represented by an attorney, the attorney may cross-examine every witness. If the defendant is representing him or herself, the defendant gets to cross-examine each witness. So that's the confrontation clause. So that's it. I know this was a long lecture. I really appreciate you hanging in there with me. We just got a couple quick notes for next week and you can get off the video. So for next week, Monday, May 6th, you're going to start the class just like you did tonight. You're going to take a quick quiz. It's a quick quiz. It's going to be on the 4th, the 5th, and the 6th Amendment. So you need to know which rights are in each of the 4th, 5th, and 6th Amendment. For example, for the 4th Amendment, you'd have to know that's about protections against unreasonable searches and seizures. For the 5th Amendment, you have to know that's where it says you have the right to remain silent and so forth. So you need to know what rights are in each of those amendments. That information is all in the lectures from last week, April 22nd, and from tonight, April 29th, plus your required reading. I'm going to put all different types of questions on the exam, or on the quiz rather. True, false. You're going to have to write in some of the answers, just mixing it up just to give you practice for the final exam. If you have any problems taking this quiz, like you have system errors, like you can't make the quiz work, you have to let me know immediately. Remember, the final exam is on Blackboard and it's 25% of your grade. You have to ensure that whatever you're using, a laptop, a tablet, whatever, that it's going to work for 3 hours. And it's going to work reliably for 3 hours. The last thing is somewhere between tonight and May 5th, please submit questions. Excuse me, I'm coughing. Please submit questions that you want answered. Sorry. I'm very sorry for that. Submit questions you want answered, because after you take the quiz on May 6th, your lecture is going to be final exam review. And I want to answer as many questions as I can that you've submitted, except these questions can be about material from any time in the entire semester going all the way back to the first week. Okay, so submit a question from material from week 1 to tonight. Okay, so thanks again. I know this was a really long lecture. Thank you for hanging in there with me. Please send me an email if you have any questions.